the question now is, how do experiences like that enter into my life as a judge? Is there any connection between these intense personal experiences that certainly judges in Edinburgh would never have had, and my legal writing? And that's what set me to writing this book called The Strange Alchemy of Life and Law. And the case in which I found the themes that I've just mentioned coming through quite strongly was called the Laugh It Off case. And the judgment I wrote there begins with the question, does the law have a sense of humour? Laugh It Off was set up by a graduate of journalism studies, Rhodes University of the Cape, who wanted to attack the hegemony that brands and brand names had in our society. I think he picked up a lot from Naomi Klein. And what he did was he produced T-shirts that took the logos of big companies in South Africa, corporations, and lampooned them. And the one in particular was Carling Black Label, the beer. It was aimed primarily at African working class men, with strong sexual innuendo that Carling Black Label makes you strong, enables things to last. It wasn't very subtle. And he called it Carling Black Labour. And he turned around this lusty, lively beer into 300 years of exploitation. The Dutch owners of the trademark were not amused, and they got their lawyers in Cape Town to get an injunction, we use the word injunction, an interdict, stopping the sale of these T-shirts. They were sold mostly to students, sort of young intellectuals, on the internet, which was just beginning to become a marketing tool again. And the judge was not amused and issued the order and ordered Laugh It Off to pay the costs. Laugh It Off took it on appeal to the Supreme Court of Appeal, and the judges of appeal were also not amused. And they said, you can criticize their labor policies, you can attack them as much as you like, it's a free country, but you can't appropriate their own trademark in order to sell your T-shirts. It was taken on appeal to the Constitutional Court. We unanimously decided that the free speech interests outweighed any possible detriment to the sale of beer. And a judgment was written by Justice Moseneki, the Deputy Chief Justice. I felt it didn't go far enough. I agreed with it. And it said, in effect, if the beer company had proved that the lampoon, the parody, had impacted on its sales, it might have been able to get an injunction. I felt that wasn't the issue. The issue was the importance of laughter in a democratic society. And can you poke fun and use laughter? You can do it at politicians. Can you do it in relation to what we used to call big business as well? And so, having asked the question, does the law have a sense of humour? This is how I ended my judgment. The Constitution cannot oblige the doer to laugh. It can, however, prevent the cheerless from snuffing out the laughter of the blithe spirits amongst us. Indeed, if our society became completely solemn because of the exercise of state power at the behest of the worthy, not only would all irreverent laughter be suppressed, but temperance considerations could end up placing beer drinking itself in jeopardy. And I can see no reason in principle why a joke against the government can be tolerated, but one at the expense of what used to be called big business cannot. Laughter too has its context. It can be derisory and punitive, imposing indignity on the weak at the hands of the powerful. On the other hand, it can be consolatory, even subversive, at the service of the marginalized social critics. What has been relevant in the present matter is that the context was one of laughter being used as a means of challenging economic power, resisting ideological hegemony, and advancing human dignity. We are not called upon to be arbiters of the taste displayed or judges of the humour offered, nor are we required to say how successful laugh-it-off has been in hitting its parodic mark. Whatever our individual sensibilities or personal opinions about the T-shirts might be, we are obliged to interpret the law in a manner which protects the rights of bodies such as Laugh-It-Off to advance subversive humour. The protection must be there whether the humour is expressed by mimicry and drag, or cartooning in the press, or the production of lampoons on T-shirts. The fact that the comedian is paid and the newspaper and T-shirts are sold does not in itself convert the expression involved into a mere commodity. Nor does the fact that parodists could have voiced their discontent by phoning into a talk show rather than employing the trademark remove their protection. They chose parody as a means and invited young acolytes to join their gadfly laughter. A society that takes itself too seriously risks bottling up its tensions and treating every example of irreverence as a threat to its existence. Humour is one of the great solvents of democracy. It permits the ambiguities and contradictions of public life to be articulated in non-violent forms. It promotes diversity. It enables a multitude of discontents to be expressed in a myriad of spontaneous ways. It is an elixir of constitutional health. I just offered that to you as a little sort of opener to get used to my voice and a certain sense of what's been going through my mind. My 15 years on the court are almost up now. My 15 years on the court are almost up now, and whatever I speak about, I can't help it, I get into a valedictory mode. So if I sound a little bit too valedictory today, it just goes, it goes with the package. Alan, thank you very, very much for making it possible for me and Vanessa and Oliver to come here. I enjoyed yesterday evening enormously. I have a strange sense of deja vu because I see the same faces staring up at me in a slightly different setting now. And I believe you've got some questions for me.